In the name of Allah, the Beneficent, the Merciful, I bear witness that there is no God but Allah, and I bear witness that Muhammad is his messenger. Assalamu alaikum. Welcome, welcome, welcome once again to Cairo Know Your Rights University. Back at you once again with another one of these educational and informational videos that we hope that you receive as such. Let us begin. Conflict of interest prevalent in circuit court. It has long been agreed that public officials occupy positions of public trust. The Constitution confers limited authority on each branch of the federal government. It vests Congress with enumerated legislative powers. Article 1, Section 1. It confers upon the President the executive powers. Article 2, Section 1, Clause 1. And it endows the federal courts with the judicial power of the United States. Article 3, Section 1. In order to remain faithful to this tripartite structure, the power of the federal judiciary may not be permitted to intrude upon the powers given to the other branches. Separation of powers. In a document entitled Ethics and Conflicts of Interest presented in a workshop for newly elected officials in Illinois, it was said, Introduction, public officers are expected to adhere to the highest standards of ethical conduct. It is unethical for public officers to use the knowledge and power of their positions to further their private interests. When private interests compete with the performance of duty, a conflict of interest arises. Conflicts of interest are prohibited by common law and statute, not only to prevent the actual abuse of power for an officer's own benefit, but also to prevent the officer from being placed in a situation that carries within it the potential of abuse. A public office is a public trust, and the holder thereof cannot use it directly or indirectly for personal profit, and officers are not permitted to place themselves in a position in which personal interest may come into conflict with the duty which they owe to the public. A public office is a public trust. Borough councilmen, as fiduciaries and trustees of the public interest, must serve that interest with the highest fidelity. The law tolerates no mingling of self-interest. It demands exclusive loyalty. The theory is that a public officer assumes the same fiduciary relationship toward the citizens of his community as a trustee bear to his cestque trust or beneficiary. They have the right to expect that in everything that appertains to their business or welfare, he will exercise his best judgment, unaffected and undiluted by anything which might inure to his own interests as an individual. Prohibited interest in contracts. Public officers may not have an interest in contracts with the governmental body they serve, subject to a few limited exceptions. The common law rules prohibiting interests in contracts by public officers were codified in statutory form and are found in the Illinois Municipal Code and the Public Officer Prohibited Activities Act. Section 3.1-55-10A of the Illinois Municipal Code states, a municipal officer shall not be financially interested directly in the officer's own name or indirectly in the name of any other person, association, trust, or corporation in any contract, work, or business of the municipality, or in the sale of any article whenever the expense, price, or consideration of the contract, work, business, or sale paid either from the treasury or by an assessment levied by statute or ordinance. A municipal officer shall not be interested directly or indirectly in the purchase of any property that belongs to the municipality, is sold for taxes or assessments, or is sold by virtue of legal process at the suit of the municipality. That's the code to that section. Another section, section 4-8-6A of the Municipal Code, which applies to the commission form of government, similarly prohibits elected or appointed officers and employees from having an interest in contracts with the municipality they serve. The Public Officers Prohibited Activities Act states no person holding any office, either by election or appointment, under the laws or Constitution of this state, may be in any manner financially interested directly in his own name or indirectly in the name of any other person, association, trust, or corporation in any contract or the performance of any work, in the making or letting of which such officer may be called upon to act or vote. No such officer may represent, either as agent or otherwise, any person, association, trust, or corporation with respect to any application or bid for any contract or work in regard to which such officer may be called upon to vote. Nor may any such officer take or receive, or offer to take or receive, either directly or indirectly, any money or other thing of value as a gift or bribe, or a means of influencing his vote or action in his official character. Contracts made in violation of the Illinois Conflict of Interest statutes are void. A public officer who violates a conflict of interest statute is guilty of a Class 4 felony, which is punishable by up to 3 years in prison and a fine of up to $10,000. In addition, the officer is removed from public office. A judgment is a contract of the highest nature known to the law, and actions upon judgment are actions upon contract. A judgment for damages estimated in money is sometimes called by text writers a specialty or contract of record because it establishes a legal obligation to pay the amount recovered, and by a fiction of law, a promise to pay is implied where such legal obligation exists. It is on this principle that an action ex contractu will lie upon a judgment. Common law conflict of interest. The conflict of interest statutes reflect long-standing common law doctrine that the faithful performance of official duties is best secured if governmental officers, like any other persons holding fiduciary positions, are not called upon to make decisions that could result in a personal advantage or disadvantage to their individual interest. Common law conflicts of interest may exist even in circumstances that do not violate the Illinois conflict of law statutes. The legislative intent in enacting these statutes was to codify sweeping prohibitions against public officials and officers engaging in conduct which divides their loyalty between their personal interest and their fiduciary duties. A case decided by the Illinois Supreme Court found that a prohibited conflict of interest in the case of People versus Charleau. In Charlotte, city commissioners negotiated and approved a settlement of a federal lawsuit against the city. In the settlement, they included an arrangement for their own employment with the city. The court stated that the commissioners had a duty to act in the best interest of the city and to refrain from using their positions as city commissioners for their own personal benefit. The court found that the commissioners, in negotiating and approving their own employment with the city, had obtained a personal advantage in violation of state statutes. A similar situation arose in Mulligan versus Bradley, in which a former village president resigned to take an employment position with the village as administrator. As village president, he had urged the other board members to vote in favor of creating the position of village administrator and to offer the position to him. 4 trustees had voted in favor of creating the new position and 2 trustees had voted against it. The village president had not voted. The 3rd District Appellate Court of Illinois held that the employment contract was void and unenforceable because it violated conflict of interest statutes that prohibited an elected or appointed official from having an interest in a contract on which he may be called upon to vote or when the consideration of the contract is paid from the public treasury. The fact that the village president abstained from voting to create the new position and to offer it to himself did not cure the conflict of interest. Indirect conflicts of interest. The conflict of interest statutes state that public officers may not be interested indirectly in the name of any other person, association, trust, or corporation in any contract, work, or business of the public body, or in the sale of any article. The reason behind this prohibition is that one should not do indirectly that which is directly prohibited. In Cohen versus Keene, the complaint alleged that Keene used his knowledge gained from his position as alderman and chairman of the Committee on Finance of the City Council to ascertain the location of various proposed land development projects. Acting through others, he purchased at scavenger sales various tax delinquent parcels located within those areas. Legal title of these properties was placed in land trusts, in which Keene held a substantial beneficial interest. Some of the property he acquired at that time was subject to the liens of unpaid special assessments. Keene recommended to the city council without disclosure of his interest that the council clear those liens, and the council adopted his recommendations. After the liens had been cleared, Keene used his official position and influence to induce several other governmental units to purchase the properties which he had purchased. The Supreme Court of Illinois stated that if these allegations had been against a defendant occupying a fiduciary position in the private sector, they would establish that the defendant had exploited his fiduciary position for his personal benefit. A public officer's fiduciary responsibility, the court said, cannot be less than that of a private individual. Keene's private interest would necessarily affect his judgment, as well as that of other aldermen whose vote might have been different had they known of Keene's personal interest. Therefore, the court reversed the low court's dismissal of the complaint, saying that these were important matters which the public was entitled to have considered. Here, in the conflict of interest statutes, Illinois has addressed a problem of compelling importance to its capacity to govern justly, preventing political corruption or the appearance of corruption. The statute at issue addresses the particular problem of public officials achieving private goals through their official actions. It sets forth a simple, direct solution. Public officials may not negotiate on behalf of the government when they would be also negotiating on behalf of themselves. In the case of McNally versus United States, it was said, under these cases, a public official owes a fiduciary duty to the public, and misuse of his office for private gain is a fraud. Also, an individual without formal office may be held to be a public fiduciary if others rely on him because of a special relationship in the government and he makes governmental decisions. In a recent decision upholding the mail fraud conviction of an Illinois judge, despite the absence of proof that anyone suffered loss of tangible property, the Court of Appeals for the Seventh Circuit reaffirmed the broad meaning of the word defraud, United States versus Holzer. Writing for the court, Judge Posner explained, fraud, in its elementary common law sense of deceit, and this is one of the meanings that fraud bears in the statute, see United States versus Dial, includes the deliberate concealment of material information in a setting of fiduciary obligation. A public official is a fiduciary toward the public, including in the case of a judge, the litigants who appear before him. And if he deliberately conceals material information from them, he is guilty of fraud. When a judge is busy soliciting loans from counsel to one party and not telling the opposing counsel, let alone the public, he is concealing material information in violation of his fiduciary obligations. The exact words used in the case of United States versus Dial are fraud in the common law sense of deceit committed by deliberately misleading another by words, by acts, or in some instances, notably where there is a fiduciary relationship which creates a duty to disclose all material facts, by silence. See Prosser and Keaton on the law of torts. In the case of, in the matter of Associate Judge Lewis versus Morgan Jr., held before the Illinois Courts Commission, it was said, the judicial article of the Illinois Constitution provides in pertinent part, Section 13, prohibited activities. A. The Supreme Court shall adopt rules of conduct for judges and associate judges. B. Judges and associate judges shall devote full time to judicial duties. They shall not practice law, hold a position of profit, hold office under the United States or this state or unit of local government or school district or in a political party. Section 14, judicial salaries and expenses. Fee officers eliminated. Judges shall receive salaries provided by law, which shall not be diminished to take effect during their terms of office. All salaries and such expenses as may be provided by law shall be paid by the state, except that appellate, circuit, and associate judges shall receive such additional compensation from counties within their district or circuit as may be provided by law. There shall be no fee officers in the judicial system. Illinois Constitution, 1970, Article 6, Sections 13 and 14. Illinois Supreme Court Rules, Canon 1, Rule 1.1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety in all of the judge's activities. Canon 1, Rule 1.2. Rule 1.2, promoting confidence in the judiciary. A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Comments. 1. Public confidence in the judiciary is eroded by improper conduct and conduct that creates the appearance of impropriety. This principle applies to both the professional and personal conduct of a judge. 2. A judge should expect to be the subject of public scrutiny that may be viewed as burdensome if applied to other citizens, and must accept the restrictions imposed by the code. 3. Conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. Because it is not practicable to list all such conduct, the rule is necessarily cast in general terms. 5. Actual improprieties include violation of law, court rules, or provisions of this code. The test for appearance of impropriety is whether the conduct would create in reasonable minds a perception that the judge violated this code or engaged in other conduct that reflects adversely on the judge's honesty, impartiality, temperament, or fitness to serve as a judge. Rule 3.15 Reporting Requirements. Canon 3, Rule 3.15 A judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with the obligations of judicial office for preventing conflict of interest. A judge shall file annually with the clerk of the Illinois Supreme Court a verified written statement of economic interest. In the case of Hugh M. Caperton versus A.T. Massey Coal Company Incorporated, it was said, the Due Process Clause incorporated the common law rule requiring recusal when a judge has a direct, personal, substantial, pecuniary interest in a case, Toomey versus Ohio. But this court has also identified additional instances which, as an objective matter, require recusal where the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. Withrow versus Larkin. Two such instances place the present case in proper context. 1. The first involved local tribunals in which a judge had a financial interest in a case's outcome that was less than what would have been considered personal or direct at common law. In Toomey, a village mayor with authority to try those of violating a law prohibiting the possession of alcoholic beverages faced two potential conflicts. Because he received a salary supplement for performing judicial duties that was funded from the fines assessed, he received a supplement only upon a conviction, and sums from the fines were deposited to the village's general treasury fund for village improvements and repairs. This qualification was required under the principle that every procedure which would offer a possible temptation to the average man as a judge to forget the burden of proof required to convict the defendant, or which might lead him not to hold the balance nice, clear, and true between the state and the accused, denies the latter due process of law. In Ward versus Monroeville, a conviction in another's mayor's court was invalidated even though the fines assessed went only to the town's general fisc. because the mayor faced a possible temptation created by his executive responsibilities for village finances. Recusal was also required where an Alabama Supreme Court justice cast the deciding vote upholding a punitive damages award while he was lead plaintiff in a nearly identical suit pending in Alabama's lower courts. Aetna Aetna Life Insurance Company versus Lavoie. The proper constitutional inquiry was not whether in fact the justice was influenced, but whether sitting on that case would offer a possible temptation to the average judge to lead him not to hold the balance nice, clear, and true. While the degree or kind of interest sufficient to disqualify a judge could not be defined with precision, the test did have an objective component. 2. The second instance emerged in the criminal contempt context, where a judge had no pecuniary interest in the case, but had determined in an earlier proceeding whether criminal charges should be brought and then proceeded to try and convict the petitioners. In the matter of Murchison, finding that no man can be a judge in his own case, and no man is permitted to try cases where he has an interest in the outcome, the court noted that the circumstances of the case and the prior relationship required recusal. The judge's prior relationship with the defendant, as well as the information acquired from the prior proceeding, was critical in reiterating that the rule that a defendant in criminal contempt proceedings should be tried before a judge other than the one reviled by the contemner, Mayberry versus Pennsylvania, rests on the relationship between the judge and the defendant. The court noted that the objective inquiry is not whether the judge is actually biased, but whether the average judge in his position is likely to be neutral or there is an unconstitutional potential for bias. Thank you once again. This concludes our video for today. We hope that it has been informative and informational and educational, and that you receive it as such. We thank you once again. Peace and blessings to you all.